Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in both Texas and Virginia. It is May the 29th of 2023, and we are here with your legal news roundup. All the legal news occurring in your world so that you can be better legally informed. Our story today takes us to the dangers of AI and relying on AI without double checking. The AI certainly has gotten more and more impressive in recent years, particularly with apps like ChatGPT and Midjourney leading the way, also with fake voice, fake video, deep fake technology. It is getting better. But at the moment, it is more of a tool. It is a very powerful tool. It's an increasingly powerful tool. It's a tool that increasingly does not require as much work from the user, but still a tool that requires the user to check and double check. It cannot be relied upon yet. It is not quite into that territory, although probably soon. Well, one attorney learned this the hard way as they just submitted a brief to a court that was created by ChatGPT without checking it at all. The ChatGPT made up some citations to cases that don't exist. And he didn't check the work at all. He just submitted it to the court as is and submitted it to the opposing party as is. Here's some cases that cite for the proposition that I'm right, but the cases don't exist. So he got busted for just simply letting the AI do the thing without checking on it at all. So, no, the AI isn't quite that good yet. Let's learn a little bit more. The New York lawyer is facing a court hearing of his own after his firm, or more importantly, him, used AI tool ChatGPT for legal research. ChatGPT is, of course, a good tool. It is a powerful tool. It is a tool that can help you in a lot of ways, and sometimes it can produce some really, really great results. Sometimes the results are less than great, though. So something you're going to want to double check. The judge saying they're faced with an unprecedented circumstances because it appears to be the first time a lawyer has got caught up in this. Couldn't swear to it, of course, but the first one that I'm aware of. The lawyer, for his part, as part of his defense, said that he was unaware the content of ChatGPT could be false. Which, wow, really? You didn't want to double check those citations? You didn't want to double check to make sure they're adequate? I've personally seen ChatGPT cite cases that are real, but completely inappropriate to the situation. I've never personally seen it make up a citation completely, but then again, I haven't used it for my work, right? So I haven't tried. Sometimes I use it to help me prep a story, and I've seen that before, and it just makes up it. Well, it uses a case that doesn't really speak to this, and it says confidently, like, this case stands for this proposition, and I go look it up. I'm like, no, it doesn't. But I go double check. ChatGPT can create original text on request, but does come with warnings that it can produce inaccurate information, which apparently he didn't see. The underlying case involves a man suing an airline over a personal injury. His legal team submitted a brief that cites several previous court cases, but the cases don't exist. Super fun and exciting. So let's turn our attention to the judge's order in this case. We turn our attention to federal court in the Southern District of New York in the case of Roberto Mata versus Avancia Incorporated in an order to show cause. When you get an order to show cause, your butt cheeks clench a little bit because things are not going great. So here's what the United States District Judge wrote in their order to show cause. The court is presented with the unprecedented circumstance. A submission filed by plaintiff's counsel in opposition to motion to dismiss is replete with citations to non-existent cases. The cases don't exist. When the circumstances were called to the court's attention by opposing counsel couldn't help noticing the cases don't exist and wrote a letter to the judge saying, Judge, we can't find these cases. We have no idea what they're talking about. Help. And the judge, got involved. The court issued an order to plaintiff's counsel to prove by affidavit annexing copies of the opinions. So we can't find them. Could you give us a copy, please? 6 of the cases appear to be bogus judicial decisions with bogus quotes and bogus internal citations. So not only are the quotes, the cases themselves false, the cases cite cases which are also false, right? Because of course cases often cite cases because it's common law, right? Cases build on cases build on cases. So it is often true that you will have a case and it will have an internal cite because that comes from itself from a different case, which comes from a different case, which comes from a different case, right? It's the way that we do this by, the way that we learn is by building on building and building. And so not only does the case not exist, the internal citation doesn't exist. That's great. Set forth is an order to show why plaintiff's counsel should not be sanctioned. The court begins with a more complete description of what is meant by non-existent or bogus opinion. Oh yes, please court, please define the problem more to make sure that we're all brought up to speed. In support of the position that there was a tolling of the statute of limitations under the Montreal Convention by reason of a bankruptcy stay, the plaintiff's submission leads off with a decision to the United States Court of Appeals for the 11th Circuit. So, hey, it's a Court of Appeals decision. Now, New York, of course, is not in the 11th Circuit, but that's okay, right? We often cite cases from courts that are not controlling in other jurisdictions. Persuasive authority, you can cite cases from other circuits, other countries, particularly, by the way, where you're dealing with international law. So if this really is the Montreal Convention, that is this, you might very well wind up citing a case from Canada. Because, if to the extent you're talking about some sort of international treaty or national agreement in particular, then those international cases are going to be, at least partially influential as to what we should do about this situation. But, not so much with the 11th Circuit. Plaintiff's counsel, in response to the court's order, filed a copy of the decision or file an excerpt. Could you please, give us the case because we can't find it? The clerk of the court of the 11th Circuit, in response to the inquiry, has confirmed there's no such case. So the judge, in addition to asking plaintiff's counsel, hey, could you please give us a copy of that 11th Circuit decision? The judge called the clerk of the court of the 11th Circuit. Clerk of the court, 11th Circuit. Yeah, hi. I'm a federal district judge over in New York. Hi, federal district judge in New York. This is the 11th Circuit. How can I help you? You're not part of our circuit. Yeah, I know that, but I'm looking for some information. Okay, like what? Well, there's this case this guy cited. Could you give me a copy? Type. Yeah, that case doesn't exist. We have no idea what it is. So the clerk of the court confirms the case doesn't exist, further states the docket number for the case is for a completely different case. So they cited a docket number. That docket number is a completely different case. Neither Westlaw nor Lexis has the case, and the case found at the citation is yet a different case. So we did look it up. Like we looked up the internal docket number. We looked up the internal docket number, the filing number that the court gives it initially. We looked up that number, and that was not the case. We looked up the number in the court reporter, the volume of all the cases that are precedential. We looked it up there, and that was a different case. So we're having trouble finding the case you said. The case in question, which doesn't exist, includes internal citations and quotes, which also don't exist. The non-existent precedent relies on non-existent precedent. The furnished copy of the decision cites a different case, which doesn't exist. A case appearing at that citation is a case that does, exist, but isn't the case you cited. It has a different name. The furnished copy of the decision cites a different case which doesn't appear to exist. The case appearing at that citation is a different name. The furnished copy of the decision cites to a different case which doesn't appear to exist. There are two brief orders appearing at that issued by the 11th Circuit on other cases. The furnished copy of the decision cites to a case which doesn't appear to exist. The case appearing at that citation is indeed a case, but not the case you cited. So the names do not match. We can't help noticing there's some minor, tiny problems. The following 5 decisions submitted by plaintiff's counsel contain similar deficiencies and appear to be fake. So this one case you cited like 6 other cases, all of which don't exist. But in addition to the case that cites the cases, you also submitted other cases which also don't exist. So here are some other cases that do not exist. Please do not cite them. Chaborn versus Egypt Air, Pearson versus Iran Air, Martinez versus Delta Air, Estate of Duran versus KLM, and Miller versus United Airlines. None of those cases exist. Please do not cite them. And thus, the judge says, could you help us out with that? Could you please order to show cause? When we asked you for the case, you gave us a whole bunch of nothing. So could you please tell us why you shouldn't be sanctioned for, misleading the tribunal, which is a violation of ethics? There is a duty of honesty and candor to the tribunal. And we can't help noticing that when we asked you for evidence, you gave us evidence and it's all fake. So why shouldn't we sanction you for, that? We have a response from the attorney, though. He would like to offer the following in mitigation of his failures. We now turn our attention to a declaration by Stephen Schwartz, who is an attorney in this case, we think. Maybe that's fake too, but we haven't gone that far. So we think he's an attorney. So anyway, Stephen Schwartz says the following. He claims that he's an attorney with the law firm of Ledavow, and Oberman, and I'm sure his law firm is super thrilled at him right now. Attorneys for the plaintiffs. He's submitting this affidavit in response to his order to show cause that originally our attorney friend over here did commence within personal injury action on behalf of plaintiffs by filing a summons and verified complaint in the Supreme Court, which, by the way, in New York just means trial court. So don't get overly excited. We filed a complaint in the trial court, and then the defendant removed this to federal court. So we initially filed this lawsuit in state court, and they asked, hey, can the federal government hear this case because of diversity jurisdiction? Okay. As the attorney is not licensed to practice in the Southern District of New York, and I'm not thinking it's going really great over here for his futuring licensing opportunities, a different associate of the law firm became the attorney on record. So he is not currently licensed before the Southern District. So he uses another friend at the court, at the law firm, who is licensed before the Southern District. And it's like, hey, can we use you as, the person who will be the person of record? Sure. Why not? You work for my law firm. I trust you. In response to the motion to dismiss, our lawyer friend over here performed all legal research, which was included. So this is totally on me. So at least I'm taking responsibility. As the use of generative artificial intelligence has evolved within law firms, lawyer friend over here consulted. That's one way of putting it. Consulting the artificial website ChatGPT in order to supplement legal research. Okay. You might want to have wanted to verify that stuff, but okay. Sure. It was in consultation with the AI. We're bringing them out as a consult. Okay. That the lawyer friend over here did locate and cite cases which the court has found to be non-existent. I do like that language, that minimizing language. Like the court has found to not be non-existent rather than are non-existent. So we're going to try to distance ourselves a little bit from this. It's like, okay, the court has found to be non-consistent as opposed to they don't exist. And then there's a citation to a bunch of cases that we already discussed that don't exist. The citations and opinions in question were provided by ChatGPT, which also provided its legal source and assured the reliability of its content. Did it though? Did it assure it? Excerpts from queries presented and responses are provided attached here too. That lawyer friend over here relied on legal opinions provided to him by a source that has revealed itself to be unreliable. Wow. Wow, that's just great work. That lawyer friend over here has never utilized ChatGPT as a source for conducting legal research prior to its occurrence and was unaware of the possibility its content could be false. Well, if you've never used it before, why did you just rely on it as complete gospel? Like, if you've used it a whole bunch before and it's always, just turned out the best results ever and proven itself reliable, I could understand maybe that you relied on it. But if you've never used it before ever, why did you choose to just rely on it blindly? Wow. This is the fault of lawyer friend in not confirming the sources provided by ChatGPT. That lawyer friend here had no intent to deceive this court nor the defendant, which, okay, fine. You didn't have the intent to deceive, you were just kind of negligent, which, to be fair, is different legally, so fine. That other lawyer friend who we used as the person who is technically like our sponsor, because we're not licensed to practice, and, we're also dragging his name through this. Other lawyer friend had no role in performing research, which again is not particularly uncommon because, sure, you can borrow me as your, as the titular head of this lawsuit, but you're really going to be the one that's driving all this work. Not an uncommon arrangement among lawyers. So other lawyer friend who's the titular head is all of a sudden like, wait a second, you technically, to be the titular head, had to swear to have a duty to supervise. And so it's like, so I will take my other lawyer friend off the hook. So that's nice of me. Neither our lawyer friend nor other lawyer friend has ever been cited for legal misconduct in 30 years of practice. And that lawyer friend greatly regrets having utilized general artificial intelligence to supplement legal research performed and will never do in the future without absolute verification, which really you should have done in the first place. Submitted by Stephen Schwartz, Esquire, lawyer friend. It's going great over here. Track 1, 2, great. Thus, that brings us to the end of the case of the lawyer who decided to use ChatGPT. No, let's try again. Thus, that brings us to the end of the case of the lawyer who decided to try to use ChatGPT to conduct his legal research. He had never used ChatGPT before, at least for legal research, according to him. And he was unaware that ChatGPT would lie to him. Now, why he would rely on a tool he's never used before and is not well known in the legal community without verifying it is sort of beyond me. Like, lawyers use Westlaw and Lexis, by far and away the most dominant in sort of this. And these services also have experimented at least a little bit internally with some AI to help facilitate research, which, makes sense because we're all trying to find these cases. And other companies also have used this as well to varying degrees to help find cases. But, they find real cases. But even where they do, you have to verify them and verify that they're good and verify that they work for what you're trying to use them for. And you actually have to go read them and check it. So you have to check to make sure they're still good cases. It's called shepherdizing. If but Westlaw and Lexis will do that for you. So you can pretty much rely on that. But you still have to make sure they're good cases. And this guy's like, I've never used this tool before. Let me just rely on it blindly. That seems like a questionable decision on every level. So lawyer friend, things are not going great for him over here. And that, for the moment, brings us end to discussion of this story. Thank you, Sledge and Wedge, for $2, saying ChatGPT getting people terminated a little bit. And Sleep and Cerebral 82 just became a member. Well, thank you very much for becoming a member. I do appreciate it. That's very, very kind of you. And good morning to all of you as well. I hope all of you are having a good Memorial Day who are in the United States. And we should obviously and thoroughly take the time to remember those who have fallen on behalf of the United States. There are a lot of people who have fought on behalf of the United States and have not come back home. And as is sometimes said, freedom is not free and never has been. You know, you have to fight. We have to fight. And there are a lot of places in the world that are not safe for people. And the fact that the United States is as safe a country for its own citizens from the whims of warlords, from the whims of even domestic oppression, from the whims of foreign oppression, goes a long way to honoring the United States. The United States is not perfect. We don't pretend to be perfect. In our own founding documents, we talk about becoming more perfect, which I think is a very nice phraseology, that we're working towards perfection. And I think the United States largely has done that. I think the United States largely has fulfilled its mandate. Again, not without problems along the way, but when you look at like the history of the world and even the history of the modern world, and you look at a lot of countries around the world, I have to say that the United States on the whole does pretty damn well by its own citizens, and pretty damn well. There are definitely oppressive elements within the United States. There is also the petty bureaucracy, which, thanks to Chevron, which we've talked a lot about, has from time to time been very oppressive on people. But even at its most oppressive, it is not the kind of despotic oppression that is present in a lot of the world. It is not the same scale or even same kind. And I think the United States is a very, very good country indeed. I have no problem pledging allegiance to the country because I think it's been very good. And whatever flaws it has, and the fact that we're allowed to speak openly about those flaws is part of what makes America great, because that's not true in a lot of the world. You know, the fact that I can criticize the government in peace is a beautiful thing. And it is significantly because of the work of our soldiers who help to protect the interests of the United States, both domestically and internationally. Again, not always without controversy, not always without blowback, not always, you know, perfectly, but they have given the last measure of devotion to this country, and they should be honored. So I honor them because so many of them gave everything for this country, and a lot of them we don't know, and a lot of them in efforts that perhaps the general public doesn't even know about, but nevertheless were important for the national cause. So honor our troops. It is something worthy of note. So however you choose to spend the day, you know, I think is a good thing. If what you do with Memorial Day is, you know, you have a barbecue with your friends and your kids' friends, or your friends' kids, you know, your kids, your friends' kids, you have a barbecue in your backyard with a pool and maybe some fireworks or something, I think that's a perfectly appropriate way to remember the day. because the soldiers fought for our right to be able to do that. Fought for our right to be able to meet in our backyards with our kids and our friends' kids, and have a beer and have a hamburger and swim in the pool and all the rest of it. And if you choose, obviously, to go to a parade or something like that, obviously that's really wonderful as well. But I think just taking a moment out of your day to say, the United States of America is a pretty good country, especially in the scheme of all countries. I think we're doing okay. All right. God bless the United States of America. In lottery news, there was recently a winning ticket in relation to a $2 billion jackpot in Powerball. And perhaps unsurprisingly, lawsuits have flown. That's not your ticket, that's my ticket, as these things are wont to do. So, yeah, we're kind of doing this thing again. Unsurprisingly, when someone wins a lottery, other people are like, wait a second, that's my lottery, which incidentally happens not infrequently, especially like when you get into these office pools. Let's pool together for a lottery, and who's part of the pool and who's not part of the pool becomes a major issue of litigation. Super, super fun. So, yeah, let's look and see what this particular lawsuit brings to bear. Let's get started with this. Jose Riviera has filed a lawsuit against Edwin Castro, who won the Powerball jackpot, which had a record prize of $2 billion, because according to Riviera, the ticket in the end that won was stolen. So we're going to try to claim that ticket was really my ticket. I bought the ticket and you stole the ticket from me. Okay. In information that has been released, Riviera assured the ticket was purchased on November 7th, but was stolen that day by another man who he didn't know who it was, and added up, he had no idea how the winning ticket ended up in his hands. So we think it was our ticket that we bought, and maybe it was taken from us at the convenience store or something. Is that what we're going with? Okay. The ticket winner went to collect his prize, but Riviera also went to the lottery office as well, claiming that he was the grand prize winner and the money should belong to him. So he made an appearance at the lottery office, no ticket in hand, and be like, I heard there was a winner, but it's really me. But I don't have ticket in hand. But it's okay. Can I have my $2 billion now? Yeah. The California lottery sent a statement. They made sure the prize was given to a real winner, but gave no further details. So at least they're internally satisfied about the issue, which, how thorough is their job, I suppose, is questionable. But they said they looked into it. With $2 billion on the line, probably looked into it a little bit, but who knows? When he went to pick up the prize, Castro opted for the $997 million pre-tax lump sum, and soon after bought a $25 million mansion. So, he won $2 billion. He got basically $1 billion in cash lump sum, and went and bought a $25 million mansion. Try not to go through your money too fast, because there have been many a lottery winner. In fact, most lottery winners wind up blowing through all the money and wind up broke. Can you blow $1 billion? I bet you can. So be careful, my friend. Be very, very careful. It was precisely in the mansion where he now lives, where the lawsuit, of course, was served. But an attorney representing, the guy who actually has $1 billion, filed a motion to annul the lawsuit, alleging that it was sent to his father, who was the winning Powerball ticket. So he says the lawsuit is no good because it was delivered on the wrong person. but or he sued the wrong person. So he sued the wrong Riviera. So he sued the wrong Castro. So fun times. For the moment, at least, the hearing is being held for July 7th, trying to figure out, did we even bother to name the right person, or did we name the wrong person? How well is that going? Thus, that brings our attention to the case of the California Powerball lawsuit for a guy who won $1 billion. That's a lot of money. 997 million to be precise. Of course, a lot of that will disappear in taxes. So it's not quite 997 million. So probably about half that, especially because California, I imagine the taxes are quite high. So more realistically, like 500 million, but hey, 500 million isn't bad, even though it's like a quarter of the $2 billion, but hey, so you lost half of it, taking it as cash, and then you're going to lose another half to taxes. So about 500 million. He's already apparently spent 25 million. So he's already, working his way through his money. So be careful, my friend. And unsurprisingly, there's a lawsuit saying it's really my money. I won the ticket. You're a thief. So we'll see how that goes. And that brings us to the end of discussion of this story. Brewster's Millions was a good movie. If you've won $500 million, may I suggest helping to support Uncivil Law? I'm a good channel. Thank you. You'd like to super chat, $100,000 or PayPal $100,000. That'd be nice. That'd be good. We can have dinner together. Buy dinner with Uncivil. Only $100,000. What a deal. By the way, if it ever comes up, here's my recommendation to you on this. First of all, if your state allows you to claim it anonymously, you should. But not many states allow you to claim it anonymously. Or I don't know if it's many. Several states don't allow you to claim it anonymously. So first of all, can you claim it anonymously is a question. If you can't claim it anonymously, can you claim it in the name of like a corporation or something? Make it slightly harder to trace you. Some states don't even allow for that. So first of all, can you claim anonymously? Second of all, if you're required to like appear before camera, like, just wear like all black, long sleeve with some gloves and like a ski mask or something. And, don't, some glasses or something, you don't have to look fancy. You just want to make it a little bit harder to identify you. Right. So it's that. Once you get the money, first thing you're going to want to do is you're going to want to, of course, take about half of it and put it into cash somewhere. I'd recommend like a Vanguard or something where we're going to put all the money anyway, but put it in cash or cash equivalent, because you need it to be liquid because of the taxes and also some legal fees. So I take half of it and just put it liquid, because you're going to have to pay taxes. There's going to be some legal fees, and so that money probably you should just treat as like non-existent. The other half of the money, I just strongly recommend putting into a nice, simple S&P 500 index fund. No muss, no fuss, right? Either that or do some sort of life cycle fund, which already exists. So, for example, the federal government is a good one to emulate. The federal government has some life cycle funds for the TSP, Thrift Savings Program, which they're public in terms of what their allocations are, and they are very, very safe sort of things, and they're they are set up to be for when you need it based on your retirement date. So you could either just put it straight into the S&P 500 index fund if you just want to keep it simple. 7% average year-on-year growth. That's average. 7% year-on-year growth. Or put it into a life cycle fund based on your age. You can just mirror the TSP would be what I do. Just mirror the TSP life cycle fund. You'd have to adjust it, every year to the percentages. So it requires a little bit more finagling. Or if you don't want to do that, find a life cycle fund that already does that for you, because I'm sure they exist on the private side that just mirror the TSP index fund. Okay. And then what you want to do is you want to only use about 2% of the money every single year. So, because that's relatively safe in terms of, accounting for, because we're trying to account for market fluctuation. So some years the stocks will go down, some years the stocks will go up. So, and also, of course, there's inflation. And so 2% is considered to be, based on everything I've read, a nice safe number to account for all these things, right? So you have 7% average year-on-year growth, but not every year is going to be 7%. Some years, the market might go down 30% or 50%, right? Some years the market might crash. So it's 7% average year-on-year growth. So you have to account for the bad times. So 2% is normally considered a safe amount. So you take 2% out every year, and that's what you spend. And if you do that, it should theoretically last forever. So I have spent some time thinking about this. And that is what you do. So if you have $500 million, so if you win $1 billion, consider half of it gone. So you have now a 500 million. Of that 500 million, you can spend 2%. 2% is 10 million a year. So consider your budget 10 million a year and go forth. There you go. Now you know. You could do government bonds as well. Government bonds don't pay as well. And you need to account for inflation. So government bonds also work. They're obviously safer. But the S&P 500 index fund has a nice long track record, right? The S&P 500 index fund has a nice long track record. Most brokers can't beat it. The something like 96% or 97% of brokers can't beat the S&P 500 index fund. The S&P 500 index fund has a nice long track record of success and reliability. So the S&P 500 index fund has been around forever and has, proven itself over the decades to be a fairly reliable growth rate, and one that most brokers can't beat. It is very rare. And also, brokers who do beat it, you also have to pay for their fees. So you lose money in the brokers themselves. So even in brokers who on paper beat the S&P 500 index fund, which is very difficult to do, and it's difficult to do reliably. So there are very, very few brokers who can beat the S&P 500 and can beat it on a reliable basis. And even where they can, they are charging fees. So it's very difficult to have a net beating the S&P 500 index fund. So the S&P 500 index fund is very, very inexpensive on sort of its load. It's very, very cheap because it's very, very easy, right? It doesn't require any human decision making. It's just the S&P 500 index fund. It's very, very simple. So it has proven itself since it was created to be an extremely reliable form of investment that has proven itself to have on average 7% year-on-year growth, and market professionals can't beat it. So the problem with government bonds is that government bonds typically don't pay enough money to beat the interest rates or beat the inflation rates. So if you're getting 3% on a bond and inflation is on average 2%, right? You're not really doing very well. Most of the money you're getting on the bonds is disappearing into inflation, especially these days. So, like a 7% growth is a much more predictable, reliable indicator than bonds. So, bonds are safer, but they don't pay very well, assuming you can get 3% and assuming that you're beating inflation. So, bonds are safer, but you're going to lose all of your money in inflation. So, the S&P 500 index fund is probably a better way to go. So, that's what I'd recommend. Yeah, 100% in SPY, exactly. Yeah, there you go. Buffett put his wife 90% in SPY. Yeah, like, there's a reason the S&P 500 index fund is a great reliable indicator that has existed for, almost what at this point, 60 years, and proven to be very reliable. So, why not go with the thing that's proven itself to be a reliable? It's basically the highest reliable interest rate you can get. You can't do any better. It's the highest reliable interest rate you can get. It's been proven to be the highest reliable interest rate you can get. You can't do any better on the in the long term than the S&P 500 index fund. It's safe, it's reliable, no muss, no fuss, easy, low to no fee. It's very low load. Get yourself a Vanguard. Vanguard is what I'd use. Get yourself a Vanguard fund, dump it all into the S&P 500 index fund. Take out 2% every year, call it a day. No problem. So there you go. I spent some time thinking about this. The S&P 500 index funds, or the S&P 500 index fund, is going to have good years and it's going to have bad years. You'll have years where it'll go up 30%. You'll have years where it'll go down 30%. But on the whole, it's a very reliable long-term indicator. So, you don't panic. You set it and you forget it. Ron Popeil style. Oh, it went up 30%. I have a lot more money. Oh, it went down 30%. I'm losing all my money. Set it and forget it. It'll be fine. If the S&P 500 index fund systematically crashes, well, my friends, at that point, we all have bigger problems. So if the S&P 500 index fund systematically crashes, yeah, well, don't worry about being poor because everyone's poor. So you'll be fine. Or at least as fine as everyone else. Or you can hire me and I'll do it for, 10% or something, and we'll call it a day. You want to do better than everyone else? So does everyone else. So does everyone else want to do better than everyone else? How much do you like gambling? You do know when you gamble that the house has a tendency of winning in the long term, right? So sure, you can do the roulette wheel thing in stock equivalent, but I wouldn't recommend it. All right. Yeah. So yeah, I wouldn't. If you win the lottery, you're going to get all kinds of calls from all kinds of brokers, some of which will be extremely well credentialed, by the way, who will promise you all kinds of things. And they may be able to deliver you all kinds of things in the short term. Yeah. So, Yes, there are some brokers who can beat the S&P 500. Yes, there's some brokers who can do it. There's some brokers who can promise you things. There's some brokers who can do it. But, a lot more people go broke trying than succeeding. So do you want to gamble that you found the one broker who can really do this? I don't care how many credentials he has. Do you really want to bank? This is the guy? How sure are you that this is the guy? Or do you want to go with my approach, which is a lot more predictable and proven reliable in the long term? I guess it's up to you. I've given you my best advice. It's your money. Good luck. I have no doubt that you can find a Harvard, Yale, MBA, CPA, tax lawyer, who last 10 years has beaten the market. I have no doubt you can find that guy. How sure are you, my friends? How sure are you? The last 10 years, he's been riding high, man. Harvard, Yale, Cambridge, Oxford scholar, you know, former Treasury Secretary, lawyer, CPA, tax lawyer for 10 years has been beating the market. I'm sure you can find that guy. Do you want to bank it all? Up to you. All right, let's move on. Where's my damn thing? Okay. In Twitter news, Twitter has been accused of not paying many of its bills after Elon Musk took over. Twitter, of course, made many, many financial commitments, and Elon Musk has been less thrilled about taking over these financial commitments. Of course, when you buy a company, you not only take over its assets, but its liabilities. And Elon Musk bought the whole kit and caboodle. So, Twitter's agreements are his agreements because he bought it over as his successor in interest. And now he's being sued by a lot of people, his landlord and other people for not paying bills. And now a PR firm has come over and said, we haven't been paid for our past agreements. So we'll see how that goes. Let's get started with this. According to Reuters, the PR firm that is suing has alleged that Twitter has not paid any of its pending bills since Elon Musk took over. Not going great. It adds that Twitter owes $8 million and comprises 6 unpaid invoices plus costs relating to his $830,000. I just assumed the comma was in the wrong place, but okay. All right. Sorry. I'll reread it. According to a recent Reuters report, a PR firm has alleged that Twitter has not been paying any of its bills since Elon Musk acquired the company. This has been a bit of a common refrain among various companies. It adds that Twitter owes it nearly $1 million, comprising 6 unpaid invoices plus a cost for the subpoena relating to the lawsuit. Joel Frank said Twitter owes $830,498 in 6 various invoices plus costs relating to the lawsuit to force Musk to complete the buyout after he tried to back out. So, give us the $1 million for the company's debts. As per the report, the PR firm also added that Musk ended its contract on November 16th, 3 weeks after the buyout closed, and no longer communicates about its payments demanding beyond an automatic pledge. So, can Twitter even cancel the contract is, of course, an issue as a matter of contract law. Elon bought the company. The company signed a contract. Elon, now a successor in interest, is bound by the same contract. So, to the extent that Twitter has racked up debt, he's obviously responsible for that. And also to the extent that the contract itself can't be canceled, because depending on how the contract was written, he'd be responsible for a breach of contract. So, lots of issues there. And if not breach of contract for this contract, other contracts that might be binding Twitter as well. Apart from this, Twitter is also being sued in Delaware by 3 former employees that include the Twitter CEO in relation to some of these issues. This goes a lot to those golden parachute provisions that they were all promised. Elon Musk is like, I'm not giving you any of those golden parachutes. You're not getting any money for a lot of the higher ups at Twitter. Again, can Elon Musk do that? That's a matter of law as it relates to if Twitter as a company had contracts with its CEO and others that said, in the event you get fired, you get, a $30 million payday or whatever the number would be, then Twitter is presumably bound by that even after Elon Musk takes over. So depending on why he fired them and how, yeah. So maybe he has to pay these settlements, maybe not. Depends on the details. It's a matter of contract law, and they're still fighting over it. Recently, of course, Elon Musk also announced that he would step down from the role of Twitter CEO, which he had previously indicated, and has indicated that NBC Universal executive Linda Yaccanero would take over as CEO. So a little bit of old media there, but perhaps a stabilizing influence for the company. We will see. I don't know whether or not being a member bypasses slow mode or not, to be honest, Rose. So I don't know that I'd promise that because I'm not sure it does. Thus, that brings us to the end of the case dealing with the Twitter lawsuit by the former PR firm who says they haven't been paid, along with their landlord, along with former executives at Twitter, along with other Twitter employees who also said that they weren't given the right severances in relation to their contracts. So, again, this is just an issue of pure contract law. What contracts did Twitter make? Elon is bound by those contracts. He bought the company. He buys the assets, he buys the liabilities, including contractual liabilities. So, all that good stuff. So, that is what's going on in that story. And that, for the moment, brings us to the end of discussion of this story. Why would being a member let you bypass the restriction on slow mode? Hmm. Hmm. Interesting. Hmm. All right. Fair enough. All right. Let's do something else. I guess this is a nice little Memorial Day story too. I wonder if I can change that setting. I'm not sure if I want members to be able to bypass slow mode. I'm not sure if that's something I can enable or not. I'll have to look into that and consider that more. Hmm. And there's little point to being a member. Well, with all due respect, you get you get behind the scenes content, such as my gaming streams. You get the emojis. You get the nice little icon by your name. And it's only 99 cents a month. I never promised that you'd get unrestricted chat privilege, and it's to help support the channel. That's what it's for, to help support the channel. It's 99 cents a month. What do you think it should cover? So, but you do get some things. You get the members only content, off-brand content, you get the emojis, you get the icon, you help to support the channel. So, yeah. In military mandate news, a retired vice admiral has spoken out in relation to a Coast Guard issue with respect to mandatory use of particular medications to treat particular diseases that were mandated by the federal government. So, this lawsuit is a lawsuit we have discussed before in relation to the COOF and how to treat said COOF. So, let's learn what is going on in the Coast Guard. The nonprofit Thomas More Society filed a class action lawsuit against the Department of Homeland Security, which during peacetime has jurisdiction over the Coast Guard. Now, speaking out on their behalf is a retired 3-star vice admiral who filed a sworn declaration, hoping it would compel the judge to presiding over the case to act. So, we are filing this lawsuit against the mandates, and we have a 3-star who says, we should take a look at that. So that's persuasive. They filed a lawsuit in the district court for the Northern District of Texas, Fort Worth, on behalf of 1,200 Coast Guard plaintiffs. Like thousands of other plaintiffs and other military mandated related lawsuits, these individuals filed a religious accommodation request. And these religious accommodation requests to not have to undergo the mandatory treatment were often denied to varying degrees. Like one branch of government granted them never. One branch of the military granted them never. One branch of the military granted it like 7% of the time. Things were not that much better in the private sector. To the extent they were granted, they weren't granted very much. So a lot of these people were like denied these accommodations when perhaps they should have been granted. And so, we have to go through that. And they might have been thrown out of the service for failure to do this. And so we're trying to deal with all those issues. I forgot to push the button. Damn it. I'll press on. Courts presiding over the lawsuits nationwide argued blanket denials of the restrictions. No. Thank you, Cerebral 82, for the 10 gift memberships. It's very, very appreciated. That's very nice of you. Courts that have been presiding over these military mandate related lawsuits, which have come from many different people, including in one case from a bunch of Navy SEALs, which was particularly badass. The Navy SEALs suing the Navy for these mandates. That was pretty cool. They've argued the blanket denials, which was true for many of them, violated the Religious Freedom Restoration Act. So there is a federal law that applies to the federal government that says that when it comes to religion, strict scrutiny is required. So that's not necessarily required by the Constitution, because we've discussed this before with this case called Smith, it being probably the principal case on issue. The US Supreme Court said in Smith, among other cases, that when it comes to religion, typically, as long as you're treating it the same as non-religion, then it's fine, right? So discrimination on the basis of religion requires discrimination on the basis of religion. So as long as you're treating the religious the same as the non-religious, it's typically fine. But the federal government passed a statute that binds itself, that says, actually, that's not the standard we want. We do want religion to have a preferred place. We want it to be subject to strict scrutiny, not this sort of equal treatment scrutiny that you've been doing. We want it to be elevated. Okay, fine, you can make that choice, federal government, for yourself, as you did. And now the federal government says, wait a second, we don't want that elevated standard anymore because it's inconvenient for us. Well, you passed a statute, my friend. So, there's that. The Coast Guard apparently is the only branch where no court has presently ruled on the issue of the unvaccinated members. Many other courts have looked at this to many other degrees and also slapped down the various defense agencies, at least in part, when it comes to these mandates. Because it's like, you have to actually consider this because the federal law requires it. Because the federal government passed this thing called the Religious Freedom Restoration Act, which sort of says, okay, although Smith simply says only equal treatment, we say, no, religion should be granted this elevated status. Wait, no, not like that. But that's what's going on. Numerous other examples exist, according to the plaintiffs, but the Coast Guard remains disinterested at best in remedying these wrongs impacting the coasties because of their unvaccinated status. Well, not to put too fine a point on it, but none of the military agencies were particularly thrilled with any of these lawsuits, and they had to be dragged kicking and screaming before the civilian authority, as we remind the military that ultimately they are subject to civilian authority in the end. So we do appreciate that they're the military and all, but in the end, the military will bow to the civilian authority because that's the nature of our country. So when the Congress passes a law like the Religious Freedom Restoration Act, the Congress has acted. And so, you can't force the military to disobey a congressional mandate because Congress is civilian and said, military, this is what you'll do. So guess what? You're going to do it. Don't you guys know how to obey a lawful order? The Coast Guard continues to maintain the mandate was a lawful order, as the right to institute it or any other mandate at will, which again has been a pretty common position from the various defense agencies on this issue. And the courts to varying degrees have been like, nah, as they've said nah to the civilian agencies as well, by the way. But because the federal military is, of course, federal in its nature, and because the Religious Freedom Restoration Act is also federal in its nature, the courts have been like, no, military, no, you're not going to do those things. You will bow to our will. And the military has to begrudgingly, to varying degrees, had to, dealt with that. So, yeah. In light of the sacrifice that many Coast Guard's people have made, the retired 3-star Admiral, William Lee, said he could not remain silent. He told the press, I chose to speak out on this issue because I have questions, as do many Americans, about ethical and legal lines that have been crossed when leaders force this treatment onto a workforce without informed consent and without the due process required under the Religious Freedom Restoration Act. So 3-star Admiral over here, who is retired, but 3-star Admiral, says, yeah, I have questions about this because federal law, and we seem to be, bound by the federal law, and we don't seem to be doing that. So this seems to be a bit problematic, Coast Guard. At the heart of the matter is trust. If the most trusted institution in America is to maintain that hard-earned trust, then leaders currently in charge should be more than willing to examine and put to bed any remaining ambiguity in the matter, else will be doomed to make the same mistake or have the same arguments the next time around. Admiral Lee, who served for 36 years, was operational commander for all Coast Guard missions from the Rocky Mountains to the Arabian Gulf. So, half the world. So, kind of important. He commanded 100 ships, over half the aircraft, and roughly 2/3 of all operational personnel. So, pretty high up in the organization at the time of the retirement. In his declaration, In his declaration, he acknowledged the Coast Guard rescinded the mandate and directed all paperwork documenting noncompliance to be removed from the service records. So the Coast Guard did eventually have to bow, but only after, threatening its members with being thrown out of the Coast Guard and court-martial and everything else. However, the 3-star says these actions are not sufficient to halt all harms they're facing. Because of the tight-knit, smaller size of Coast Guard, it is the smallest of the uniformed military branches, so, a relatively closer community. Personnel decisions being made are still strictly adversing the members. Because of this, he said there's a very strong likelihood institutional memory will harm the reputation. So even though these have been stricken off the books, maybe those commanders will remember, Excuse me. Okay, I kind of lost my train of thought there for a second. Give me a second. I'm just going to move on. Following his declaration, he says, comes with considerable personal angst, for I find myself at odds with the institution I love and with current leaders whom I respect. So yeah, I imagine there's a little bit of difficulty because, being a 3-star admiral, probably knows these guys personally because the Coast Guard is relatively smaller, although still badass. The Coast Guard does not get enough respect. They hop onto the drug submarines, which is pretty badass. So, they do some real work out there. And, they save people from boating accidents and keep the peace and also do a lot of civilian work. So they're a good group, man. Coast Guard needs to get some more love. Sandra Ramirez gives 10 gift memberships. Thank you, Sandra. That's very, very thoughtful of you. Very appreciated. The current case represents over 1,200 conscientious objectors that aim to protect the constitutional rights, not necessarily recover large damages. They say it's their hope the Coast Guard will do the right thing, admit to past wrongs, and make whole those brave men and women who refuse to violate religious beliefs. In our constitutional republic, religious freedom should be esteemed, not assailed. And the federal law would tend to agree because of the Religious Freedom Restoration Act. Of course, the Supreme Court has also got involved in many of these mandates as well on the civilian sector. And Justice Gorsuch, for his part, in one of the cases said that the mandates were the greatest intrusion of civil liberties in peacetime of this country, which, probably it's hard to think of a bigger one to some degree in peacetime. In wartime, of course, Korematsu comes to mind. But in peacetime, yeah, this is a pretty big intrusion of people's rights. Sandra, by the way, just a friendly reminder, but I believe you have sufficient permissions to change whether or not slow mode is active or change whether or not it applies to subscribers or not and stuff like that. So just a friendly reminder, by the way, that in the future, if you see bots, you have the ability to change those modes, I believe. So, just reminder that you can do that. Thus, that brings us to the end of the discussion regarding the Coast Guard, which, like many other military agencies, put in place a mandate with respect to particular treatments as it relates to the coup, and many military people sued, including, perhaps most notably, the SEALs, which was pretty badass. So a lot of these lawsuits have gone forward, and a lot of them have gone to some success. Not necessarily universal success, but the Defense Department has definitely received a bit of a black eye from the civilians who are like, no, not so much. And of course, now the Coast Guard, which is not technically under the Department of Defense, but rather Homeland Security, at least during peacetime, also has to have these issues resolved. So although the DoD has gotten a couple black eyes, maybe not so much as it applies to the Coast Guard, so that still has to be resolved. So all that stuff going on, and that for the moment brings us end the discussion of this case. Yeah, if you don't already have sufficient permissions, I'm not sure that I can give them to you. Oh, you are a standard mod. I thought you were a managing moderator. Okay, we'll make you a managing moderator. Hold on. Okay, I think you can do it now. Who are my managing moderators? Yeah, well, Sandra, you are now. So go nuts. I need to figure out who are my managing moderators. I want to figure this out. Give me a second. Hold on. I'm going to go into my own backend because I'm curious. Will it tell me who my own managing moderators are if I log into my own backend? Let's find out. Yes. So Christina is, and Sandra is. Okay. Okay. Fine. Who are these other people? Who's Rain Maniac and why is he a managing moderator? Anyone know who Ran Maniac 10 is? Before I change it? Secret McSquirrel is still listed as a managing moderator. I have no particular desire to change that. All right. I'm not sure how Rain Maniac became a managing moderator, but they're not anymore. So now it's just Christina, Blackleaf, which is me, Sandra, and Secret McSquirrel. Okay, that'll be fine for the moment. Great. Let's see. Where the hell was I? All right. Okay. All right. Here's a short story, which just seemed like such a bizarre story. But here's a short story. It seemed weird. In unexpected and somewhat strange news, a South Carolina civil rights group wants to rename the case Brown versus Board of Education. One of the most famous cases of US Supreme Court history, but they want to change the name of the case. And they're filing to change the name of the case of Brown versus Board. Okay, that seems like a very strange thing to do, but fine. The Civil Rights Group of South Carolina is going to petition the U.S. Supreme Court to change the name Brown versus Board. Over the next 3 months, the group representing past plaintiffs and descendants plan to file paperwork asking the court to reorder the set of 5 cases that led to Brown versus Board. The group wants to replace Brown versus Board with the South Carolina case that was filed earlier but is lesser known. In Briggs versus Elliott. So the group sees the name change as a way to restore South Carolina as the cradle of the movement to desegregate. Everyone else lays down and says you can't do this. You totally can't. This doesn't make sense. Says the South Carolina civil rights photographer who has been at the forefront of the effort. Many will call it crazy. It might be laughed out of court. It will be. To Williams and 20 other families who signed their names to Briggs, it's worth the effort to try to right what they view as an injustice. If this court is ever going to reconcile with history, this is a good place upon the 70th anniversary of Brown versus Board. The Briggs case, which was filed in 1950, was the first such case to be taken to federal court. Brown came nearly 9 months later. Uh-huh. Okay. Thus that brings us to the end of this strange case. And, not for nothing, but it's not always the first case that gets the Supreme Court's attention. In fact, it's somewhat rare that's the first case that gets the Supreme Court's attention. So, yeah, this case might have been filed 9 months earlier, but it wasn't the case that got the Supreme Court's attention. Brown versus Board was the case that got the Supreme Court's attention. And as it was noted, there were other cases that were filed around the same time on around the same issue. And they were all kind of dealing with this issue. And Brown versus Board was the one that the Supreme Court said, okay, let's take that one up. But we're mad because our name isn't the name that got known. It isn't enough that we fix the issue. We want the case named after us. So, all right. So that's something we're trying to do. We're trying to rename Brown versus Board. I don't see how that really works, because if we follow that logic all the way through, then we'd have to rename a whole shit ton of cases. Because again, it's somewhat rare that it's the first case that gets the title. So I guess we're going to rename like all the Supreme Court cases pretty much. So that should be fun. I'll have to relearn new case names. Exciting. And that brings us to the end of discussion of this case. The casserole, by the way, turned out very well. It could use a little bit more salt and pepper, and it could use more cheese, and it could also use more hot sauce. So, but all those problems can be fixed, of course, after the fact. Those are all easy problems to fix, right? Just put some more cheese on top, melt it on top. It'll be fine. Get some more salt and pepper, get some more hot sauce. No problem. Those problems can all be fixed. But it turned out very, very well. So I had 2 portions last night, and it was really good. Thank you for reminding me to push the button. I appreciate it. We didn't add any bacon. That's true. We could have put bacon in the mix. Are you changing the lights, or do I have to yell at you? Thank you. All right. Could have put some bacon in there. Yeah, could have put some bacon in there. So, and also it was perhaps too much onion, because we used a whole relatively big onion, and it was a little onion heavy. So I would have cut down the amount of onion that I used, maybe only used half as much onion, and more salt, more pepper. But like, it's not unpleasant. It's nice. But I'm gonna have some more after this. I'm hungry. I'm hungry, man. I want some food. You can avoid the bowl overflow by just adding the pan and mixing there. Yeah, I could have done it that way, but then it wouldn't have been as much fun. Yeah. So yeah. But fortunately, it's sweet onion, which I do prefer the taste of. So even though there's too much of it, it's not really sharp onion flavor. So it's not that big a deal. Shut up, Jerry. All right, let's see what's going on here. Now, do I want to cover this? How long is this thing? Hmm. Vox is pissing me off today. Above the law is pissing me off. Do I want to get pissed off by Vox or do I want to get pissed off by above the law? What's the difference anymore? Let's get pissed off by Vox. Let's give this a try. All right. Thank you, Sandra Ramirez, for the gift memberships. Kurt is single, yes. I've ever thought about writing those recipes down. That assumes that I've written recipes. Just kind of like eyeball it, which is also like why I wound up with a little bit too much onion. All right. Well, Pauline, if you think I'm a catch, good for you. I'm available. Isn't that a good thing? Or maybe you don't, maybe you don't think I'm for you. I don't know. I don't know. All right. In, in hysterical reaction to trying to actually follow the Constitution time, Vox over here notes that Clarence Thomas's opinion would bring back child labor because Clarence Thomas has problems with how the Commerce Clause of the Constitution is currently being applied, as I do as well, because it doesn't really flow from the constitutional text. The Constitution gives the federal government the power to regulate interstate commerce, which namely is trade between the states. And thanks to a case called Wickard versus Filburn, which we've discussed in great detail, this allows the federal government to reach into states and get to pretty much purely intrastate activity that law at least has some impact on interstate commerce, which is kind of all of it. So yeah, Clarence Thomas thinks that this doesn't make sense because it's not what the Constitution says, and Vox is over here like the apocalypse is nigh, which is just like actually reading the Constitution, which Vox apparently has a problem with. So let's read this and respond to the Vox stupid. On Thursday, the Supreme Court decided Sackett versus EPA, dealing with the Clean Water Act unanimously, I believe. Was it unanimous? Or was it like 7-2? Shit. Hold on. It was unanimous. Great. On Thursday, the Supreme Court imposed limits on the Clean Water Act. The court's decision in Sackett versus EPA, which was unanimous by the Supreme Court 9-0, is likely to do serious harm to the government's ability to quell water pollution, including major waterways. No, it just prevents the EPA from saying that everything everywhere is under their jurisdiction because water goes everywhere. It prevents them from going onto people's private land and saying your private land is part of the waterways because your runoff will go across the street and run into a ditch, which will run into a creek, which will run into a stream, which will run into a river, which will run into a lake. No, it will not really have major impact on the EPA's ability to regulate the waters of the United States. No. And even if it does, that's because of the way that Congress wrote the law. So the Supreme Court is just interpreting the law that Congress actually wrote. So is that a dire consequence? Maybe, but it's what the courts are supposed to do. Reading the words on the page. Meanwhile, Justice Thomas wrote a concurring opinion that would severely limit the power to legislate. They might as well take several volumes of the U.S. Code and light them on fire, possibly because many of them are in violation of U.S. law because they are not supported by the Commerce Clause, because the Commerce Clause gives the federal government the ability to regulate interstate commerce. That is commerce between states, interstate, between states, not within states. So yes, this might radically reduce the power of the federal government, but that's what the Constitution says. The words on the page, my friend. To be clear, the concurring opinion is not law. It merely reflects the views of the justices who sign on to it. And this particular opinion is unlikely to garner five votes to become law. But that doesn't change the fact that Thomas and Gorsuch is only one of 9 justices, and their views tend to shape the ideas of lawyers and judges throughout the legal system. Also, by the way, not that Vox has necessarily been paying attention, but this is by no means the first time that Clarence Thomas has written things like this. Because Clarence Thomas has been decrying this part of the law for quite some time in quite a few opinions, because he's been fairly consistent on this view. He believes that the Commerce Clause has been wildly misinterpreted. I don't know necessarily I would go as far as Justice Thomas was, but I do overall agree that the Commerce Clause has gone too far because it allows the federal government to reach into activity that purely happens within a state and doesn't transverse state lines. We're not talking about tariffs between states. We're not talking about, states trying to restrict trucks or trying to restrict ads or trying to restrict things. We're talking about wholly intrastate activity. The federal government's law does not apply to this. The 10th Amendment says all powers not given to the federal government are reserved to the states and the people. So the Commerce Clause, which gives the federal government power to regulate the trade between the states, does not go to purely interstate. And the Constitution says that's for the states. That's just what the Constitution says. It's the words on the page, ma'am. Under the approach Thomas lays out, the federal ban on child labor might be unconstitutional. Maybe, in some situations, possibly, because there might be businesses that are purely intrastate. So would the minimum wage. Federal laws protecting the right to unionize. Bans on workplace discrimination, nearly all other regulation. As it relates to businesses that are purely interstate, maybe. As to the larger companies that transverse state lines, probably not so much. So probably would not impact, large chains that are in between states. But as for businesses that are wholly interstate, yeah, it might very well do, because that's the limits of Congress's power. Thomas's approach would endanger countless gun laws. Well, not for nothing, but also the Second Amendment, by the way. So also interstate commerce, but also the Second Amendment when it comes to the guns. Rules requiring health insurers to provide people with pre-existing conditions, to bans on white-only lunch counters. As a matter of federal law, quite possibly. As it relates to some of the businesses, as it relates to some businesses which transverse state lines, perhaps not. So as it relates to large companies that have multiple different businesses in multiple different states, yeah. Would this go to health insurance? Maybe, maybe not. But it wouldn't impact wholly within state businesses because the Constitution doesn't authorize it. It is unconstitutional. Why can't you read the words on the page? Though Thomas has said similar things in the past, yes, he has many, many times. His opinion in Sackett is one of the most nihilistic opinions written by any federal judge. No, it's not nihilistic. It's just saying this is what the Constitution says. The federal government's power is limited. It is a government of limited powers, or to put it another way, a government of enumerated powers. The 10th Amendment confirms this. All powers not given to the federal government are reserved to the states and the people. That means that the Constitution of the United States sets out the powers of the federal government. These are all the powers of the federal government. This is all that there is. Enumerated powers. This is a classically conservative view. This is not new. All right. Justice Thomas wants to take it to perhaps a wide extreme, perhaps wider than I would go in this domain. So Justice Thomas may indeed be wider in this respect than me, I would think. But, the overall thrust of what he's saying is classically conservative. Enumerated powers, reservation of powers to the state, limited federal power, looking at the actual text of the Commerce Clause, trade between states, looking at the actual text of the Second Amendment, right? We might disagree as to some of the scope of this, but Justice Thomas's opinion, even though perhaps he wants to take it further, is not incompatible with overall conservative legal thinking. This is pretty standard. Vox seems to be discovering it for the first time for some reason. Neil Gorsuch, who was appointed to the court, has not revealed just how far he's willing to go in sabotaging the U.S. government. Again, the U.S. government is doing a lot of things that are perhaps unconstitutional, at least in some respects, in this respect. So now there are two justices who are willing to commit judicial arson. Wow. Because they're willing to actually uphold the constitutional text. Again, we could disagree as to how far it goes. Justice Thomas has a tendency to go much further than I would go. And I think further than Gorsuch would go. But the idea that a lot of this stuff the federal government is doing is unconstitutional because it violates the plain text of the Constitution. It's just what the Constitution says. Much of Thomas's opinion is an attack on what he calls New Deal era conceptions of Congress's power under Commerce Clause. That's an accurate description of what it is. It is a New Deal conception of Congress's commerce power. That's just accurate. That's factual. Thomas argues that Congress should return, or court should return, to a narrower understanding of power to regulate national economy that follows a case called Hammer versus Dagenhart in 1918. An infamous and long overruled decision striking down a law that prohibited good produced by child laborers from being sold in U.S. markets. Well, as it relates to between states, maybe, right? To the extent the goods are transversing state lines, then maybe that's interstate commerce because it's trade between the states. So if the federal government wants to say, okay, you can't trade between these goods, maybe that is a valid exercise of Commerce Clause. So maybe this decision, maybe the decision that says you can't trade in these goods because they're produced by child labor, maybe that's constitutional. Okay. Thus, and then he would go even further than that. The primary thrust of his opinion is the federal government's authority over channels of interstate commerce, roads, waterways, railroads, and such, is limited only to the power to keep them open and free from any obstruction to navigation. Okay, is that correct or not? I don't know. I haven't actually thought about that, to be honest, in that domain. So should we get into the channels of interstate commerce? What does it mean to regulate, for example, roads, waterways, railroads, and infrastructure? Is all that it means is to keep them open and free? One would presume it would allow for uniformity in sort of those things at a bare minimum. So I don't think I would agree, assuming Justice Thomas goes that far. So if Congress wanted to say that, railroads, because they travel interstate, have to be made this way so that they're compatible, that's probably constitutional. If Congress wants to say, the roads have to be this way with signage this way, So because people travel on the roads between the states and therefore uniformity in our signs and stuff, that's probably legal. So do I agree this far? Probably not as far as Justice Thomas wants to go, but this is his idea. Okay. So he might want to go further than me, but the underlying idea that if it's wholly within a state, we can't get to is what the constitutional text says. Taken seriously, this approach could gut much of the rest of the Clean Water Act. I don't think that's necessarily true because a lot of rivers are very interstate and the lakes that feed into them are interstate. So does this completely gut the Clean Water Act? No, I don't think so. I don't see it. And could allow a company to dump countless toxins into the Mississippi River, so long as the poison did not prevent ships from traveling around. No, I don't think it would or should extend that far. The Mississippi River very much travels between states. I think the EPA can regulate the Mississippi River. I think they can go that far. So assuming Justice Thomas thinks that all they can do with respect to the Mississippi River is keep it open, I wouldn't agree. I wouldn't agree with that reading. The river clearly travels between states. You can regulate that. That's fine. And the tributaries that feed into it and they're indistinguishable from it, I think that's fine. So I wouldn't go this far. It's worth emphasizing, of course, only 2 members of the Supreme Court have signed on to it. There's probably little risk that Thomas and Gorsuch will get their way soon. Although, of course, it's worth emphasizing that Trump got to appoint 3 Supreme Court justices, so the court's center of gravity could lurch sharply to the right at a very short period of time. Wow. Amazing. Justice Thomas perhaps taking the principle too far, but actually just reading the constitutional text. Wow. But the fact remains that 2 of the most powerful people in the country, de facto philosopher kings, who serve for life and cannot be removed from office except by impeachment, have so little regard for the people of the United States that would wipe away many of the foundations of our modern society and scoff the consequences. Well, again, the federal government seems to be acting in unconstitutional ways. Not all of it, a lot of it is proper under interstate commerce authority, particularly in the modern era where interstate commerce is, planes and trains and cars and vehicles and all the rest of it. So I don't, think that everything the federal government would be wiped away, but there is some of it that is wholly intrastate that, yeah, this is a problem, but it would wipe away the foundations. It's just doing what the Constitution says. It's in the text, people. Read it sometime. The Constitution in the text permits Congress to enact laws with respect to commerce with foreign nations and among the several states and with Indian tribes. That is the text. Congress can regulate commerce with foreign nations among the several states and with Indian tribes. The Congress of the United States has tried to sweep a lot of shit into this language because commerce kind of goes everywhere. And they're like, so our power should go everywhere. This is the primary constitutional provision giving the federal government authority over private businesses. Yes, including its ability to ban discrimination, protect workers from exploitation, and protect the environment. Well, yes, that's true. That is correct. That is the dominant text. Correct. You are correct, sir. The question of just how much power Congress should have has historically been a contentious question, in large part because society Americans live in today would be unrecognizable by the people who drafted the Constitution, which at least in part suggests maybe that we have strayed far. So, yeah. In pre-industrial United States, most business took place in local marketplaces that had minimum interaction with economies of other states. Debatable. Depends how you look on it, but certainly not the cars, planes, trains of the modern era, but boats were very usable. So I'm not sure how true that is, but okay. A farmer in Iowa would grow grain in Iowa, sell to Iowa, and rarely compete with farmers in other states. Probably true. Yes. Certainly there were merchants who engaged in interstate international trade. Yes. And the Constitution was written to allow it to regulate. Yes. But in early America, there was a meaningful distinction between local and national. I don't know. I still think there's a meaningful distinction, at least some of the time. Again, in our modern era, this has become a little bit more blended. So I appreciate that, but there still are local businesses that do things locally. So this distinction hasn't completely evaporated. Vox writing that the atomized economy disappeared after the United States built a railroad. Okay. Vox writing that the atomized economy disappeared after we built the railroads. Somewhat. Suddenly, the same Iowa farmers' grain would be shipped to Chicago, where it would be intermingled with grain grown on farms. Then it might be sold in New York or Virginia or even somewhere overseas. Okay, well, to the extent that the grain is traveling interstate, then the federal government could probably impose restrictions on it. So it's like, okay, Iowa farmer, if you want to sell your grain or transport your grain over state lines, it must conform to these standards. I think that Congress can probably do that. So if they wanted to sell it wholly intrastate within the state, and say, no, we're not going to ship out of state at all, then, okay. If they want to sell it out of state, they get a bigger market. They get the big market, but it comes with conditions. So it's like, what do you want? Do you want the really big market so you can sell your grain everywhere? But that comes with some conditions, or do you not want those conditions? You might have some conditions imposed on you by the state, but do you want our conditions for our big market? So some businesses will take the deal because huge markets, some businesses won't, but that's their choice to make. So I don't know, that's fine. The history matters because the Commerce Clause only permits Congress's ability to regulate commerce among the states, or commerce which concerns more states than one. In pre-industrial America, most businesses concerned only the state, so they're beyond federal government's authority. But in modern industrial economy, there's no such thing as a purely local marketplace. I would disagree. There are local marketplaces. Businesses routinely trade among state lines. That may be true for many businesses, not true for all. And even if one individual only sells their good to local consumers, that merchant must still compete with goods throughout the United States and sell those goods at a price that's competitive in the marketplace. That may well be true, that they have to compete with goods that are being imported into their state. So that may, as a matter of economic reality, impose certain pressures on them because of free trade between the states. So yes, it is true that, our purely local merchant over here will have to compete with stuff that comes from beyond the state lines, but some people might want to buy stuff that's purely local. Some people like that purely local. And so, they may very well be able to compete. And, the people who don't care, they don't care. So everyone's happy. Let the market decide. That's how we normally do this. The same Commerce Clause the framers drafted in the belief it would give Congress only limited power became a much broader power to regulate virtually any business transaction in the United States. It sure did. It has been read extremely expansively to the point where it doesn't make any sense to my legal mind. Needless to say, this expansion of federal power, an expansion that's entirely consistent with the constitutional text, bullshit. Bullshit, it's entirely consistent. Bullshit, it's entirely consistent. No, a lot of it is, much of it is, but there's a significant amount that is not. Many businesses will want to trade interstate. They'll want to continue trading interstate and do things interstate and Congress's power will continue to be quite expansive. But for wholly intrastate activity, not so much. But this power didn't sit well with the industrialists. They didn't want to pay their workers a minimum wage nor stop hiring 6-year-olds to work in their cotton mills. Well, first of all, states can regulate that. And the federal government, as always, can bribe states. This is typically what they do, right? So if the federal government can't do it directly, the way the federal government typically solves this problem is with bribes. It's like, hey, state, yes. Have you considered banning the child labor? No. Well, if you do, we'll give you money for XYZ. And states go, yay, money. So it's the same way that the drinking age is 21. Can the federal government mandate a drinking age of 21? No. The drinking age is 21 in the United States because every single state has passed a law saying it's 21. They don't have to. They don't have to do that. The states could say 18 or any other age that pleases their fancy. It's completely up to them. Why has every single state said 21? Because the government bribed them with the highway funds. Hey, highways are expensive. Would you like to have highways? Yes, we would. Hey, we'll give you some money for the highways if you have a drinking age. And the states went, yay, money. And so, what was true for the drinking age could be true for the child labor laws, one would imagine. Beginning in the late 19th century, the various people have convinced the Supreme Court to impose increasingly arbitrary limits, they say, on Congress's power, although more arbitrary was the federal power because it was pretty unmoored from the text. These are the same limits that Thomas and Gorsuch want to bring back. Well, at least some of them, yes, because the constitutional text applies to interstate trade between states. So businesses that operate in multiple states, goods that flow between states, Congress can pass lots of regulations, I'm sure. But the purely local firm that does purely local and is purely local market, probably not so much. And if you want to regulate that, Congress, bribe the states. You're pretty good at it. You've been doing it a lot. The high watermark of courts' efforts to shield private business was Hammer versus Dragonheart, a 1918 business that struck down a federal ban on child labor. They reached this outcome by defining the word commerce very narrowly. Commerce includes transportation of persons, land, property, as well as purchase, sale, and exchange of commodities, but doesn't include the underlying making of the goods. Which, okay, that makes sense. That seems logical. Thus, under Hammer, Congress could regulate the size of railroad cars that shipped goods, and it could regulate actual sales, but was powerless to enforce the working conditions. It was powerless to ban child labor, except in limited circumstances where children were employed in shipping or sales. Maybe. Yeah, possibly. This decision maybe goes too far in its own reach because we'd have to consider this decision is 1918, right? So like in 1918, as Vox itself pointed out, in 1918, there were a lot more local businesses. The nature of national trade was not as deep as it is now, as it was 100 years ago. Now, there's a lot more trade, and trade flows a lot more freely. And the world itself has grown a lot smaller, as we're starting to import things a lot more from China on a more regular basis, for example. So in 1918, these kids were probably less interstate than they are now. So under the facts today, the logical decision probably wouldn't go as far. So that doesn't necessarily mean the decision was wrong. The decision might be right. But under the facts of today, it wouldn't go that far because obviously the facts change. And the same law, as the facts change, will have to come out with a different outcome. So in 1918, was this correct decision? Maybe. I don't know. I honestly haven't looked into it, in extensive detail. It's not a case I'm well familiar with. But even if it were correct, the decision today would have to come out differently because of the nature of trade. But wholly intrastate commerce, to the extent it exists, this would be correct. In the Sackett versus EPA opinion, Justice Thomas wrote in his concurring, the Commerce's clauses, text, structure, and history all indicate at the time of founding, the term commerce consists of selling, buying, and bartering, as well as transporting. This meaning stood in contrast to production activities like manufacturing and agriculture. So selling, belling, and bartering, but maybe not manufacturing. I'm not sure I necessarily agree with that part of Justice Thomas's opinion. He might be right, but maybe not in their modern era. Vox here knows that's the exact same argument as that underlying argument that we just discussed from 1918. So, okay. And it was a case that doomed a generation of children to hard labor for meager pay, was correctly decided, and rigid limits on federal regulation should be imposed on the nation today. Yeah, because the federal government has exceeded its mandate. There are many reasons why the Supreme Court eventually abandoned the distinction between transportation and sale and the production of goods, but one of them is that it's completely unworkable. Perhaps it is perhaps it is an unworkable distinction in the modern era. Perhaps that's true. I don't know. I haven't really thought about that particular aspect very deeply. So maybe at one point that distinction made sense. Maybe now that distinction makes less sense. So, fair enough. If the distinction doesn't make sense anymore, then again, because of the change in facts, we would have to change the legal analysis. So fair. Maybe production should be included as commerce. Okay, that might be true. Even if Congress can't forbid a factory from producing goods using child labor, why can't it use its authority over transit and sale of goods to prohibit items being used by children, being sold or transported? I'm not sure that they can't, by the way. I'm not sure that they can't, right? So if Congress can't actually forbid child labor, which I don't know if they can or not, because I haven't really thought about that particular issue very deeply. But even if it can't, it could probably say, yes, you can't sell the goods between states. So that might very well be a valid regulation of interstate commerce. When the goods are traveling between lines, yes, to gain access to the national market, you must agree to these conditions, one of which is not so much with the child labor. So maybe that would be a valid regulation as it relates to the goods that are traveling state lines. The goods that come between state lines can't be produced by child labor. Maybe that's perfectly fine. As the Supreme Court said in 1941, which overruled the Hammer decision, the court's child labor decision cannot be reconciled with the conclusion that the power of Congress under the Commerce Clause is plenary, which is another way of saying absolute, to exclude any article from interstate commerce subject only to specific prohibitions of the Constitution. In other words, Congress is allowed to ban from interstate trade, and that includes any product that's produced by exploitative practices. I think that's probably correct. So I think that decision is right. If the goods are traveling between the states, Congress has the ability to regulate it. That's probably legally correct. So I think I agree with that decision. Thomas's opinion in Sackett, they say, would produce even stricter limits on federal government's authority over private industry than Hammer did. Thomas would not only restore the distinction between transportation and production, which I'm not sure if I agree with that. I'm not sure if that's possible. I'm not sure if I would say that. I don't know if I agree with that or not. Haven't really thought about it to that level of depth. So I'm not sure if I'd vote that way. But he also claims that Congress's ability over channels of interstate commerce are limited to the power to keep them open and free from obstruction. I'm not sure if I agree with that either, by the way. So Justice Thomas and I may depart slightly on some of these points. Justice Thomas's opinion may be a direct response to Darby's conclusion that Congress may exclude any article from interstate commerce and may use this power to effectively ban goods that are manufactured. After all, Congress's power to regulate transportation is limited power to keep roads, rivers, and railways free. It turns out that Congress would not be able to ban illegally manufactured goods. Yes, that would flow, and I'm not sure it should flow. So I don't know that I agree. If Congress, all they can do is keep the roads, rivers, and railways free from obstruction and not ban trade in interstate goods, then yes, Congress would not be able to ban trade in interstate goods. But Congress has the ability to regulate trade between the states and presumably can ban goods that would violate its dictates. It uses the ability to sell to a national market as an incentive to agree with its rules. So I don't think I agree. Assuming Justice Thomas wants to go this far, I would not go this far, I don't think. In any event, we have now gone pretty deep into theoretical underpinnings that allow the modern day regulatory state to exist. Yes, we have, but those underpinnings are not so much theoretical as constitutional. They are what the Constitution requires. It is the constitutional text. Assuming that we should do things other than the Constitution, we can amend the Constitution, which is hard, but it's what the Constitution says. So we should do what the Constitution says. That would be good. The one important point to understand from this very technical conversation about constitutional law is that decisions like Darby laid out a legal framework that makes it possible for the federal government to regulate private industry. Yes, they did, in a way that violates the Constitution. So is it a little technical? Yes, we're getting deep into the weeds of the Constitution. We're getting so deep into the weeds of the Constitution. They extend to areas of the Constitution that I have not explicitly thought about. I've thought about some of these issues, but I haven't thought about the distinction between selling and production. I haven't thought about it really deeply. I'd have to think about it a lot more. I'm not sure I agree that there's a distinction. Maybe there was at one point, but maybe not anymore. But it's what the Constitution requires, so let's do that. Countless laws, including anti-discrimination laws like the Civil Rights Act and the ADA, environmental laws like the Clean Air Act and Clean Water Act, and basic workplace safety regulations like OSHA, exist today because of this being overruled. And the Supreme Court stopped placing arbitrary limits on the Commerce Clause. But the limits of the Commerce Clause are baked into the text itself. The Commerce Clause doesn't give it it is self-limiting. It's constitutional text. So are the limits arbitrary? It's what the text requires. So yeah. And Thomas and Gorsuch would sweep all this away. Uh-huh. Thus, that brings us to the end of the discussion about Clarence Thomas's new opinion in Sackett versus EPA, where he expresses, as he has done before, his current concern with the Commerce Clause, which, as we know, because we've discussed all too many often, reached its peak in a case called Wickard v. Filburn, a case I very much disdain because it makes no logical sense under the Constitution. So Thomas, looking at this, says, hey, a lot of what the federal government is doing may not be constitutional because it's not. It's not constitutional. Congress has the power to regulate trade between nations, between states, and with the Indian tribes. That's what it can do. So Congress has the ability to regulate goods as they transverse state borders and can use the incentive to transmit stuff internationally and between states and to the Indian tribes. They can use that incentive to get things from merchants because they can say, hey, if you want access to this market, these goods must be this way, and if not, then you can't sell them. And some people may take that bargain and some people may not. And even to the extent that they wouldn't want to take the bargain, Congress may be able to impose it on a lot of businesses anyway because of their reach and scope. So this is not, but yeah, for a purely local business, the national government wouldn't have power. So it doesn't quite reach the parade of horribles that Vox wants you to think. Vox wants you to think the end is nigh. The end is not nigh. Clarence Thomas may want to take this to places that, are perhaps a bit extreme. I don't necessarily disagree with Justice Thomas's conclusions on some of the more extreme elements of his conclusions, but the overall thrust of what he's saying often makes sense because his opinions are rooted in the constitutional text and, as they should be. So we have a bit of a disagreement on what the constitutional text means, but, that's okay. But Vox over here is like, let's abandon the Constitution completely because it would upend the federal government and that would be bad. But the federal government is limited by the Constitution. So, there's that. So all the rest of it. And that for the moment brings us to the end of discussion of this case. Didn't Roberts use Commerce Clause as a reason to uphold Obamacare? No, he did not. He did not use Commerce Clause as a basis to uphold Obamacare. He used taxing authority as a basis to uphold Obamacare. So I didn't read Thomas's concurring. No. I didn't read Thomas's concurring. That being said, however, in Sackett, I didn't read his concurring. However, I have read several of his concurring opinions in other cases, and I know from Justice Thomas's writing that he often goes further than I would go. So my comments are based on my reading of Justice Thomas in other cases, but I didn't read Justice Thomas's opinion in this current case. But yeah. Swoop, thanks. Push the button. Great. All right. We finally get our attention to Florida Man. so we can bring this stream to an end. I need food. I need to go to the gym today. And then I have improv today. So, yeah. Perhaps slightly down today, so I don't need a flood of orange hearts or anything, but just, sharing, just slightly down today. Hold on 1 second. I want to check something real fast. Give me 1 second, please. Where the hell is my... Hot one. Mods, you missed one. Oh, no. KitKat got there. KitKat got it. I was about to chide you. But you got it. Good job. Good job. Good job, KitKat. All right. All right, let's do Florida Man. In today's Florida Man case, Florida Man claims he broke into a house to hide from a ghost. Okay. So we broke into a house to escape an ethereal entity. Unclear why he thought the ghost wouldn't be able to enter the house. So this defense would be what we would consider private necessity. Would be the basic underlying legal theory about why we did this. Okay, I technically broke into your house, or I technically stole your car, or I technically did these other things. But I had legal necessity. I did the thing because I was trying to escape some horror, and this was the necessary method for me to escape the horror. So I guess we're going for a legal necessity defense. I broke into your house, yes, but it was legally necessary. Why? Ghost. Okay, let's see if we can make this legal necessity defense work. Let's get started with this. Florida man Andrew George over here is jailed for allegedly breaking into a home because he claimed ghost. George over here was booked last week for 2 counts of burglary, which again, technically legally is when you break into a home in order to commit a crime therein. So if all he did was break into the home to escape the ghost, then that would just be criminal trespass, but we think maybe he entered for some other reason. So if ghost, he's not guilty of burglary. So if ghost, he's not guilty of burglary. What were his true intentions though? According to the arrest report, dispatchers were called to the home for what they said was a shooting, but turned out to be a burglary, or so they say. When officers arrived, they found the man, later identified as George, laying down on his back in front of the steps of the home, covered in blood and crying out in pain. His accomplice was standing out on top of him. So things are not going great as it relates to the ghost. We're having some problems. After speaking with the individuals involved, police say they had purchased a room at a nearby travel inn. They were in the room for about 30 minutes when they claimed they heard a window opening and thought someone was trying to break into their room. Okay. The two allegedly ran out of the room and demanded a refund from the motel manager, arguing for several minutes. They were, in fact, refunded. So, okay. But moments later, they observed a shadow behind them. Think it was the person who was breaking into the room. The two ran across the street in an attempt to hide from the shadow. Okay. I'm curious at this point whether some sort of pharmaceuticals of some point may be involved. But you know, there might be some evidence that they actually thought they were trying to escape some entity. So that burglary count is looking a little bit shaky. And our private necessity defense, well, that's not going great, but you know, hey, it's something. The duo claimed they ran into a 7-Eleven and asked for help, then ran towards Halifax. George kept running around the parking lot due to a ghost chasing him. He told officers he was scared of the ghost and scared the ghost was going to harm him. So he jumped into water to hide from the ghost. Apparently, his friend thought he fell into the water, so apparently helped him out, and then the two ran across the street. Still feeling they were being chased by the ghost, he approached a few homes and banged on the front doors, screaming for help. He allegedly said at one point they grabbed a chair and smashed it through a window, then punched open a different window. The people inside, for their part, of course, called 911 and threatened to stab him with a kitchen knife if he didn't leave. Which, you know, fair enough. You have had a person come into your home, you know, who is clearly not acting right. So your self-defense is looking pretty good, right? His legal defense for this is not burglary / it isn't illegal at all is separate and apart, of course, from the self-defense argument. So we have to switch our frames of reference, right? So even if we somehow conclude that this isn't illegal on George's part, the homeowner's ability to use self-defense goes to their perspective, and obviously their perspective is, yeah. George allegedly told officers he couldn't get into the home due to God telling him the female was a bad person to hang out with. Okay, the suspect also told officers he heard children's voices and didn't want to scare a child. So he didn't enter the home? So even trespass is looking a little bit shaky now. Okay. George admitted to taking Molly, known as ecstasy, and that's why he believed God was not protecting him from making bad choices. George's arraignment is scheduled for July the 18th at 8:30 a.m. Okay. Hold on. I got to check out something real fast. Hold on. Yeah. Okay. Yeah. All right. Okay. All right. This is fun legally. We can have fun with this. All right. Thus, that brings us to the end of this story about the Florida man who broke in to see a ghost. And legally, things are more interesting than you might expect. All right, first of all, burglary is a specific intent crime because it requires you to have the specific intent to do a thing, namely to commit the felony therein. So unclear that we broke in with intent to commit a crime therein. Also, he was high on drugs at the time. Now, being high on drugs will not help you in a general intent crime, right? But it will help you in a specific intent crime. So I was high on drugs actually will legally work as a valid defense to the burglary. So it's also not clear what happened in relation to the home. So that he had the intent to commit a crime therein, not clear. Even assuming that he had the intent to crime therein, he was high on drugs and couldn't legally form the intent, is a valid defense because it's a specific intent crime. So that's fun. Also, he has the makings of a private necessity defense because he thought he was trying to escape a ghost. So I broke into the home because I tried everything else, guys. I tried everything else. I tried, leaving the motel. I tried going to the 7-Eleven. I tried jumping into the water. I tried other steps before breaking into the home. And it was my last resort. I broke into the home, private necessity. This is fun. So we could try that and see how that works. So first of all, I don't think this is burglary legally. So I would absolutely 100%, as his criminal defense lawyer, say this is not burglary. It's not. As to the trespassing offense, I think about making my private necessity defense and see how far that goes me. I'd probably be laughed out of court, but it'd be fun as I tried and see how that goes. And so also for the friend, one of them didn't enter the building. So how are we charging the friend? Because what are we charging them with? Conspiracy? Accessory? None of that's even clear. So as to the other friend who didn't enter the building at all, I think there's no legal liability there. Because, we're just trying to help a friend in need. The fact that our friend is crazy out of his mind, if we didn't enter the building, I'm not sure we did anything illegal. So friend probably should get off scot-free. This guy, his charges need to be reduced at bare minimum. And that brings us to the end of discussion of this case. But because it's private necessity, he would still owe financial damages. So that's a distinction between private necessity and public necessity. So if he broke into the house because it was necessary to save some disaster occurring on the community at large, I don't know what scenario this is. I'm just saying, like a classic example was, I burned down your house in order to be a fire break. Like that would be an example, right? If you could somehow prove that, which is a whole nother set of problems, but if you could prove it, right? I burnt down your house because it was necessary to save everyone from a calamity. If you can prove that, general necessity, public necessity, no liability. Homeowner, sad. Probably not getting paid out by their insurance either, by the way, in this scenario. So it's just sad for everyone all the way around. Public necessity. But if we did it for private necessity, we do owe damages relating to this. Was this on my bar exam? I don't think this was on my bar exam, but it was definitely on a bar exam I studied in prep for the bar exam, where we had this kind of scenario. So we had this scenario where there was a woman who was at a gas station. This is bar exam problem. Woman at a gas station, getting gas, her kid's in the back seat. As she's filling up for gas, like a guy comes to her, I think with a gun, and like gets into the car and takes the car and drives away. Mom, completely freaked out of her mind, commandeers some other guy's car, and starts to chase after him, right? And so as we're trying to do what can we charge various people with, right? So we've got the guy who stole her car on kidnapping, grand theft, and a whole bunch of other shit. But for mom over here, who stole a car, private necessity. So mom gets no criminal liability, but she does have to pay for damages to the car. And for whatever financial inconvenience that the situation caused. So she does have to pay, but no criminal liability. The more you know. It's a similar thing to justification, right? Justification, yeah, it's like justification in that respect, right? So it's like, yes, I committed the homicide, but it was justified homicide, self-defense, right? That's the difference between homicide and murder. Homicide is I killed a guy. Murder is I did a bad. Can you kill a guy without doing a bad? Yes, we call it justified homicide, right? It says self-defense. So justification is one way to get out of liability. Necessity is another. They did it because it was required. I did it for the better good. So yeah, necessity. Yeah, so fun times. So I don't think girl over here, I'm not sure girl over here. Well, who entered the house? Oh, the accomplice was standing over him. No, wait. But he's the one bloodied. Okay, so I'm not clear who actually entered the house. It's a little vaguely unclear who entered the house. So I'm not sure. One of them might not be guilty of anything. Because I'm not sure this is a conspiracy. I'm not sure it's accessory under the circumstances. So one person, I'm not sure they're guilty of anything. The other person, not guilty of burglary. This doesn't seem like a burglary. So plea it down to criminal trespass and call it a day. And again, all this does nothing with respect to the homeowner, with respect to self-defense. Because again, we have to look to their point of view. So from their point of view, the self-defense is warranted. So no liability there either. Let's take a look at super chats. Cerebral 82 gave 10 gifted memberships. Sandra gave 15 gift memberships. Sledge and Wedge gave $14.56 worth of super chats today. Kick ass. Yeah. I'm having a good time now. My mood has improved. And then it would be really interesting on like the necessity defense to the degree to which that's objective versus subjective as a matter of state law. Like, does the necessity, how's that work as a matter of state law? That's a state law specific question. Because usually, like, someone's pure, like, usually it has to be like a necessity that like is objective, like everyone would recognize as objective. So I'm not sure. I believe ghost, although some people believe in ghosts. So maybe. Well, thank you everyone for being here today. I'm going to now sign off and do things. I'm first of all going to eat because I'm hungry. And then I'm going to, I need to still schedule the video for 7:00. Only one video posted yesterday. I'm not really sure why. So I'm not sure how I screwed that up. You know, there's a lot of things to keep straight and only one edited video. But yesterday I'm not sure what happened. But anyways, we'll keep going on. I need to schedule the video for 7, and then I also need to schedule tomorrow's videos at some point because I'm going to do improv tonight and need to schedule them. So I need to do that. And then I really should go to the gym today. And yeah, I'm going to sign off for now. I hope all you guys are having a great day. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.